Hello, everyone, and welcome to the second of two sessions for today's Lawyers Weekly AI Innovate. My name's Jerome Dorasami. I'm the managing editor of Lawyers Weekly. For those of you who have just tuned in, this second session, we are going to be discussing how AI is reshaping litigation from discovery to judgment. I'm very pleased to be joined for this session by Joseph Raymond, who is the Chief Executive Officer of Automatize, and we are very pleased to have Cicero by Automatize partner with Lawyers Weekly for this session. Joe, welcome.
It's a pleasure to be here. Thank you.
There is so much for us to get to. For the benefit of our audience, and certainly for those who didn't tune in for our earlier session, if you have questions for Joe during the course of this session, please shoot them through on the chatbot on the screen in front of you. That chatbot is called Slido. Those questions will come through to me on the iPad here. We will allocate time towards the end of this session to get to those questions. If you have asked a question that is particularly pertinent to whatever Joe and I are discussing in the moment, we may throw to that question at the time as well. Joe, to start off, for those who perhaps hadn't heard of Automatize or its product Cicero, would you mind giving us a bit of an overview for who you guys are and the work that you do?
Absolutely. At 10,000-foot overview, Cicero is a case analysis platform. It's designed with input from litigators for litigators. We launched our product about a year and a half ago, June of 2024. That was with one client we'd been working for in the background. That was Watt& Carney. We have subsequently launched into 17 other firms here in Australia, and through our ALSP partners, an extra 30 firms globally. So we feel that there's a bit of wind behind our sails with respect to the momentum that we've got.
No doubt you were on the forefront from those early days, but yeah, there's certainly been a lot of change in that time.
I'd love to actually dive into that. What's changed
Please.
since the start of this new technology? We found that many lawyers will love prompting; they'll jump straight into it. I'm going to call it 5% of the total population of lawyers. There's probably another 25% of lawyers that can be trained very well to prompt, and they're in the scope of who you might be able to get you using your tool through strong organizational change management. A further 30 that will say, actually, you know what? I've had it logged in and I haven't had the best experience. I'm not going to log in again. And 40% might not log in at all.
Mm.
But we found that the evolution of our product from a prompting solution through to providing immediate insights into your case just by loading your documents has been transformative with respect to how we get adoption, how we get meaningful insights and actually move the needle.
Yeah, and that offers us a really good segue into the crux of our conversation today, which is all about how AI has reshaped litigation or continues to do. And I guess as a starting point to this broader conversation, Joe, I'm curious to know from your perspective how much AI has reshaped litigious workflows. Are we still just scratching the surface, or have some of the processes and approaches been completely upended already?
Yeah, good question. I'd say that we're scratching the surface. We are seeing what I'm seeing broadly in the market is that there's been a lot of experimentation with AI across various different firms and trying to work out where it best can fit. There have been two schools of thought. The first one is broad but shallow, giving everyone access to certain tools that can assist us as some of the commercially available AI tools can, but within a private enterprise setting. And that's seen some level of adoption and certainly improved AI literacy across the board. But what we are seeing as the highest value return on investment from AI is narrow but deep when it comes to assessing how AI can be applied against your firm's workflows. And it's that is, I'd say that right now, assuming the technology doesn't actually improve any more than it does at the moment, if it doesn't get any better, there's still 4 years, 5 years worth of development that you can throw into the existing tools of how firms can further integrate this currently available technology into their workflows and expose more tasks to automation.
Okay. Just further to that point about wide but shallow versus narrow but deep, that probably really speaks to the differences that you might find in specialist tools versus more generic ones. With that in mind, why from your vantage point do the specialist tools really outperform the generalist ones when it comes to the various workflows for litigators?
I think that tools are a reflection of their users. You wouldn't send your family solicitor who did your will to argue in the High Court, just as you wouldn't get an esteemed silk to do a commercial contract review. That's the reality is that law is not a monolith. There are many different types of practices, and each have their own diverse approaches and nuances. We have built in Cicero a very much a something that's designed to start from the very beginning of a matter where all the way through to the end stages of litigation. It starts by when you create a matter in Cicero, everything is petitioned by a matter by case and by client, so that we can ensure information boundaries and help lawyers collaborate when they're part of a team. The very first thing we'll do is ask where it's up to. Is it this is pre-litigated dispute or is this a litigated matter?
Mm,
And if it's a litigated matter, we'll ask for the initial pleadings.
yeah,
And from that initial pleadings, we will then work out how many defendants are there. And we then invite the lawyers to add their defenses or whatever in the jurisdiction that you're operating in.
yeah.
From that point, Cicero then extracts out the claims, the defenses, the facts as they've been alleged in the statement of claim. And for every one of those particular allegations, it works out the position of the defense and it produces a pleadings matrix before you've even done anything within the tool. It does this extremely accurately and automatically without the need of complex prompting or having to enter, say, for every allegation, provide me a list of verbatim allegations indented in such a way. It removes a lot of the complexity that you would otherwise see.
Mm,
From that, we've seen the key metric that we use here is the speed to insight. How long does it take before you've loaded your documents into the tool to actually get value from this, having removed the variability of having to learn how to prompt this thing? So
yeah.
I hope that in part
No,
answers your question.
yeah, absolutely. But it really speaks to the ways in which Gen AI has changed the game, the landscape for litigators across the country, and not just some of those litigation processes, but also e-discovery and the processes surrounding that. For those listening who aren't as familiar, what's your perception of just how much Gen AI is changing the landscape with litigation and e-discovery?
So it's still very early days. We would say that we've got fairly decent take up of all of the tools out there that we've seen. We see a very steady rate of new clients coming in every month and increasing amounts of our existing clients, uplifting the number of users who are using it. That having been said, though, as a percentage of cases in Australia that are being where generative AI is being used and used effectively, I'd say it's still single digits across the board. I really don't feel that this has been something that has really made its mark yet. We're seeing a very constant uptick and a rapid acceleration of adoption. I might just, you mentioned e-discovery. I think there's a really solid series of use cases around e-discovery that specialists, just tying it back into our previous topic, can really nail out. One of the most concerning aspects of generative AI adoption is variability. If you run a query over a series of documents and you get one result, and then you run the exact same query a moment later and get a slightly different result, it's very hard to stand by that in court, especially in
Mm,
litigation. It's a very litigation specific challenge. So what one of the things that we've seen is that it's not just the use of generative AI that moves the needle, but generative AI in concert with tried and tested technologies that have existed over the last 20 years.
mm.
So I would say that when we're talking about AI here, I want to talk more broadly
Of
about the
course.
full spectrum of how this technology works, not just the latest at the forefront, and then the chat GPTs and Claudes and
Mm,
Googles that you might have seen to date.
yeah. Just as a follow-up there, what's your perception of the willingness or readiness from litigators across the country to, I guess, break free of some of those shackles of skepticism or fear even when it comes to being able to take advantage of this changing landscape? Do you see that shifting at all?
I'd say that I've seen two schools of thought. I've seen some firms that have been at the forefront of this, and their workforce is highly educated on how this technology works. And when they decide to invest in a tool, they're able to get perhaps a faster return on that investment. I've also seen folks that have taken a very different approach. Don't worry about becoming so immersed in AI today. AI will come to you. And I think that's the path that we've decided to take our application down. We
Okay.
are throwing less on the users to adopt this technique, to learn how to prompt. Prompt engineering was not taught in any university. There's not a single person who has graduated university before 2023 who would know anything about it unless you're in a computer science and a highly specialized field.
Mm,
So to all of a sudden expect an entire workforce to adopt a new series of technologies and forced to learn how to work in these particular tools, we think is not all that reasonable.
yeah.
What we're saying is we've come up with ways, having worked with our clients, every single feature in Cicero can be drawn. The feature that we've got can be drawn to a series of requirements that we've had through in-depth conversations with lawyers and try to work out how they've used it, what they could use, how they could use it better, and then taking that what they're saying there and working out the actual problem that we're solving and incorporating back into the tool. And through that process, we've been able to build something that just like that pleadings matrix that gets generated without a single prompt, is providing insights that it's a bit of a counter narrative, I guess, to some of the other things that might have been discussed today. But I don't think that the onus is on the user.
Mm.
It's on the onus on vendors to build technology that's useful to their users with as minimal reskilling as possible.
Joe, just to clarify, how does that align with the approach we hear about quite a lot that lawyers just need to get started, go in and experiment and play around with it, suggesting or advocating, and forgive me if I'm misinterpreting what you're saying, but
Mm.
are you suggesting that perhaps lawyers can be a little bit more reactive rather than proactive on this?
Look, I think for their own literacy, for a lawyer's own literacy and education, learn it's never hurts to learn more about how AI works. And in particular, if you intend to use it in any way, shape, and work, learn how it doesn't work. Understanding the fail modes is very important. That having been said, I think we are at the start of a journey where vendors will need to create their platforms to be far more accessible than they currently are, immediately provide insights. I'll give you an example of another feature that we're literally rolling out right now. And this has been something that has been on the wish list for about 8-9 months now. But at the same time, we feel that our understanding of how lawyers work, combined with our understanding of how the technology can be applied, combined with advancements in the underlying models that of how these technologies, has only just reached the point where we can do this. We've been asked for a list of who's who in a matter. Sounds very simple. Tell me who are the people that are in this particular matter, who are the parties, who are the key witnesses, who are the potential witnesses, who are the organizations that are referenced, what are the aliases of various different people and how do they interact, then tell me where they've been, what allegations have they made and what allegations have been made against them. Seems relatively straightforward, and if you prompted something in a general purpose tool, you probably get some of the way there over time in a sort of disjointed series of unstructured responses. What we've done in the background is to listen to that need for a definitive list of key players in a litigation. And when we take a series of documents that get added to Cicero, we will feed it through this processing engine where we explicitly extract person A, person B, person C. That is, it's a very similar name to person C. We'll put this into a bucket that needs to be double checked by a human to say, is this an alias of that particular person?
Yeah.
And we go further. We work out when we're doing that data pre-processing step, which is just such an important aspect. To look at things through the lens of a litigator is so completely different than looking at the things through the lens of a contract lawyer or a conveyancer or someone working in a risk advisory capacity. Looking at this through a litigation lens, you're looking to work out not only who is mentioned in this text, but what have they said? When did they say it? Was this contemporaneous or was this retroactive retelling? Was this directly said by them or was this hearsay? Is this an objective fact? Is this an allegation? Is this an assertion that's being made by a witness? Is this an expert opinion? Now, if you had that list of who said what, when, where, why, and how, you can couple that list of people who are mentioned, people who are talking, combine that into one big list and say, this is what they've said. Upon looking at my documents in Cicero, without a single prompt being run, I can look at my list of key players and say, these are my people, these are the potential aliases, and this is what they've said. And we go a step further and we say, here are the potential inconsistencies in what they've said across the wider corpus. We provide a view as to the credibility of potential witnesses in a way that we know generative AI works. There's no prompting involved. There's no guesswork about how to get the exact phrase right. We understand that these instructions work behind the scenes, and we've built this into our platform, and we are so excited to be rolling this out in January.
Yeah. Just a reminder for those of you watching from home or from the office, if you have questions for Joe about anything pertaining to how AI is reshaping the litigation landscape, you can send them through on the chatbot called Slido on the screen in front of you, and it'll come through to me on the iPad, and we will get to those questions at the end of this session. Joe, I want to move in a different direction now and ask you about the role of defensibility and auditability
Mm.
in legal AI. First of all, it might be helpful to unpack these terms, why they're so significant, but what do you see as being the role of both defensibility and auditability with the proliferation of AI that we're now seeing?
So it means different things to different stakeholders within a firm. Our clients, the applications for Cicero we see are in a combination of transactional high volume disputes, complex disputes, and also e-discovery teams that are assisting litigation. Now, when it comes to defensibility, if you're looking to use generative AI to work out which documents are relevant to a matter for the purposes of disclosure, you need to know that your results are unquestionable, that there's no algorithm that is decided behind the scenes to not include something that potentially could be relevant by some measure of relevance. So that's what I mean by defensibility. You need to be able to, if you're needing to stand by some of the results that you found in court, you need to be able to get the same result every time, and it needs to provide a good reason. And the way we've done that is also in a way that addresses auditability. We've built this system to first and foremost use a combination of predictive coding as well as generative AI. When someone asks a question or an issue has been detected from the pleadings list, we will first and foremost identify using a combination of traditional data science metrics, potentially semantically similar documents inside a corpus, to then say, this is my seed sample. The AI will be sent through to a smarter AI to then review those particular documents and push them into the bucket of relevant, borderline, or not relevant. And from those relevant documents and that listing, it'll actually train a model that's been around for 20 plus years. It sits in the back end of a relativity or a UX to be able to identify potentially additional documents that are relevant. And it will keep going through that process until it's labeled and eventually drops off and finds no relevant documents anymore.
Mm.
And because this is using tried and tested technology that's accepted by the courts underneath the hood. Just to be absolutely clear, it's accepted by the courts in the form of e-discovery tools, which Cicero is not, for the purpose of discovery. It's always going to provide the same responses there. So it's not relying on a fundamentally non-deterministic tool to
Mm,
provide a deterministic output.
sure. And how inextricable are these processes to litigators moving forward, do you think?
The, that result I've just told you there is built to be quality controlled. Every single document inside Cicero, every single page reference it provides, there's a facility for a manual review, what we call a strong labeling system, and that provides a level of auditability so that when you're going to rely on something in court, when you're going to review and analyze your documents and work out what's relevant and what's not, you've got not just a paper trail of what the machine has done, but the humans that have come in over the top to fundamentally safeguard those processes. That provides all of us, that opens up a series of repeatable processes that can be used in large scale e-discovery processes, while at the same time also providing litigators who don't have the support of e-discovery teams some of the advantages of being able to review a very large volume of documents very quickly. Now, if I was going to get out my crystal ball here and discuss what that might look like in a couple of years, once this technology is widely saturated the market and fully adopted, and there's been a time for this information to settle and these work practices to evolve with what the technology can do today, I would say that you'll be able to see litigators and particularly smaller firms able to take on much larger cases that would previously have been too big for them to handle from a resourcing perspective. We've lowered the barrier of entry, so you no longer need a computer science degree to be able to take advantage of some of the capabilities here. This is a tool that we built Cicero to appeal to transactional litigators, to complex litigators, and to e-discovery personnel. So when you log in, you can use it no matter what your position is. What that means is it's a low barrier to entry. So it means that you can potentially, in addition to arming David with the rocks to take on Goliath, you're also in a converse position to be able to evolve some of the workflows that you would have seen to date around technology assisted reviews. I'm seeing those fundamentally in the future scope for how you might be able to get far faster insights and find facts far faster than you otherwise would have, especially in larger matters as well.
Mm, okay. So then for law firms who are listening to this, be that big or small, or perhaps some of the sole practitioners, how can those businesses, those practitioners, safely deploy AI within regulated environments? Obviously, the regulation is shifting in this space, and we've got to remain compliant with all of that. So, what constitutes safe deployment
Uh,
of a platform like this moving forward?
Rule of thumb is stay the heck away from the commercially available tools that if you're going to use client data in your AI practices. This is in the public domain. There's a New York Times lawsuit against OpenAI and Microsoft where supposedly private conversations that were advised as being subject to being deleted, currently being held by court order and segregated for the purposes of the Times reviewing if any of those particular conversations might have breached their copyright facilities. There's First of all, be aware of where your data is being located. If it's Secondly, if you've got a firm with various different policies on what systems can be used, adhere to those policies. If you're in the position of setting those policies for firms, work with your trusted providers. There are a few of them here in Australia that guarantee that the data will not be used to train models, that it will not be shared with third parties, and that it can be accessed securely and safely from behind your firm's firewall. We are one of them, but there are plenty of others. That information is just like the basics of due diligence you would need to do when choosing a tool. One other aspect I'd say there would be to use it safely. There's the privacy and security aspect to it, but there's also a regulatory aspect to it. There are practice notes that specifically here in New South Wales, which I believe are very sensible. It's absolute that the court's right and responsibility, and they've taken this responsibility very seriously to impose limitations on how AI can and should be used.
Yep.
And it's every legal professional's obligation to be aware of those constraints, up to and including not using this for the generation of affidavits, for not using this in the construction for understanding where it's been used in the construction of expert reports, and absolutely when it comes to checking your citations that you're using, if you're using AI to help you assist in research tasks.
Also, that safe deployment of these new technologies will also depend on the level of trust that a practitioner or a law firm has the technology. What's your sort of broad take on that?
Look, I think trust comes with the use case. We stayed away from research use cases because we're not one of the two big firms out there that have that really comprehensive data set that can be used in the construction of an interesting and a valuable solution here. We stayed away from drafting initially because that's where we can see the majority of hallucinations is in generated content. We focused on what we believe to be a very safe use case, which is document review with a human in the loop, and to act as the ultimate line of defense to ensure that the context has been correctly understood.
Yeah.
So when it comes to trust, I would petition it rather than looking at AI as a monolith. I would take it back to the use case that AI is being deployed in within your firm. and understand where AI works and where it does not. If you are a seasoned lawyer who understands their area of law very well, some of those riskier use cases become less risky because you can tell good from bad very quickly. If, however, you're just starting out and you've got no idea how that might relate to the practice of torts, don't rely on AI to tell you these things first. Do your reading independently and learn how this will fail and where you can fail in using this tool.
Yeah. I suppose that really goes to the importance of a lawyer being able to properly explain or audit or, I guess, defend how AI has reached certain conclusions and why they've ultimately then used AI in your work. Because if you can't do that, then perhaps you're not deploying the technology very safely.
Absolutely.
Yeah. So then, taking all of that into account and everything else we've been discussing so far, Joe, what do you see as being the key takeaways and lessons learned from the early adoption of litigation-specific AI as we finish up 2025 and come into 2026?
I'd say that lawyers don't like prompting.
Yep.
I've seen that some really are very good at them. Others, I don't think it's realistic to expect partners who have been practicing their own particular way for 20, 30, sometimes longer years to all of a sudden have to upskill themselves to meet what the market has to offer. I think that the market needs to do better. We're trying to do that, and we've done that through our pleadings matrix, evidence matrices, dramatis personae, the ability to immediately find across each of the pleaded facts the contradictory and supporting evidence that is there for human review to make sense of within a fact, the ability to determine inconsistencies without someone having to hold this information in their head at any given time, the ability to make sense of the facts, the claims, the defenses, and the factual issues.
Mm.
We fundamentally believe that AI is only going to move the needle so far as it's been invested inside the workflows that matter and how well the builders of those workflows understand the work that practitioners are doing and how far we can go to avoid practitioners from having to reskill and learn completely new skills that in some instances might be they're not absolutely not bad ones to have and enable some options, but should not be mandatory if you're going to make use of a new
Yeah.
technology.
And just as a follow up there, do you think that litigators, broadly speaking, are cognizant of these lessons that we're seeing, or are they perhaps oblivious, or somewhere in the middle?
I think the ones that are using Cicero are seeing a
Yeah,
few of these
of
advantages,
course. Yeah.
but I also say that one of the things that we have a couple of different forms of currency. We do like real currency, that's one part, but our second currency is feedback, and we take compliments, we take constructive feedback, we also take insults, and we get a
Okay.
lot of we get less of those these days than at the earlier iterations of our product. But that having been said, though, the litigators that we're talking to, there are some unbelievably switched on and capable people out there,
Mm.
and I have some of them working for me, but I'm also really happy for the ones that are not working for me but working with us in pursuit of actually applying this technology into their practices, because we're not a law firm.
Mm.
We'll never be a law firm. We are there to assist law firms in what they do. I'd say that undoubtedly there is a high level of cognizance as to what this technology does and can do. They're usually the people working with us.
Let's move to some audience questions now. And so I'll bring those. Oh man, we just got a heap in the last 5 minutes, which is nice.
Fantastic.
Alrighty, so where shall we start then? What are the key challenges firms face when integrating AI into discovery and judgment processes?
So into discovery, you need to be understand why and every single one of the documents that has been placed into the discoverable production set has been referenced as such. And you need to be able to understand the ones that should not be included. If you're not doing a full manual review for every one of the documents involved in them, if you're using keyword searches and plus AIs on top of it to produce a list of discoverable documents, you also need to screen the ones that should not be shared. That means potentially personally identifiable information, privileged information, confidential, and trade secrets. Interestingly enough, AI actually is very good at picking up those. And that's where some of those prompting skills actually do pop up.
Mm.
Because if you've got a very subjective view as to what potentially pertains to be a trade secret or criteria for which information might be considered privileged.
How do you see AI reshaping the role of lawyers in litigation while maintaining ethical and professional standards?
So, ethical and professional standards require lawyers to be familiar with their cases and to read their documents. AI can help to inform lawyers which documents to read first. If you've got 50,000 documents and a relevance check in a discovery tool or some other platform has determined that they're all probably relevant or relevant to the categories that have been set for discovery, it's a very long and painful task to read all of them. If you had a tool that could say, hey, read these 500 first, and you'll have 90% of your case positioned for you, and you've got that listed for you within a day of having received your tranche of information, that's valuable. And
Yeah.
that's how I see AI more and more intersecting with how lawyers work.
Got a couple of questions here that pertain to defensibility. How are specialist AI tools changing the way litigation workflows handle accuracy and defensibility?
I'd say that they are It's evolving. I don't think that there's any one tool out there that can replace the existing infrastructure that's been in place for the last 20 years. I would say, however, though, that this is, I'll give you an example of a proposed flow. If you look at the technology assisted review process, there's two iterations of it. There's TAR 1, which fell out of favor pretty quickly because it just didn't align to how lawyers work. And that was where you take 10,000 documents or 500 documents or something along those lines, and you'd have someone look at every single one of those documents and say helpful or not helpful, or not. And that became your first review batch that you could use, then go and train your entire predictive model on the next subsequent set of models. That fell out of favor pretty quickly because it just doesn't align to how people like to work. That led to the advent of TAR 2, which was a human would look at a series of documents, and a process called continuous active learning would occur in the background, where every document that you were marking as either relevant or not relevant would actually feed and move some documents to the top of the list and some to the bottom. And eventually, the ones at the top of the list that were likely relevant would eventually drop off. And after a while, you'd say, looks like we're done. What we're seeing with AI is all of a sudden TAR 1 is now possible again.
Yep.
You've got something that can act as in machine learning terms, a weak labeler, although to be completely honest, it's a very strong and capable system and it's getting better every day. That could potentially label 10,000 documents in the first instance, work out what's relevant, not relevant, borderline, and that can be used to train subsequent models. And that's the technology that we use
Yep.
under the hood. And of course, you can have humans in the loop to validate that, which we absolutely insist on when people use our tool. But at the same time, working out to see whether you agree with what the AI says versus reading the document from start to finish and coming up with your own decisions is potentially a significant time saver.
Okay. You have somewhat answered this question already, but I'll ask it anyway. How can firms ensure that AI assisted decisions remain defensible in court?
Okay, so I wouldn't use AI to build decisions. The understanding of whether AI can assist in the judiciary, and I do not see judges using AI anytime soon. I see that as almost apocalyptic in its application, and I'm really hoping that we don't go down that path anytime soon. If you're looking to work out how AI can be used to justify decisions, as in decisions made by the various different parties about what to include or exclude, use it in concert with existing tools and court-approved frameworks today.
How important is explainable AI as we move towards more agentic AI?
I actually don't like agents in litigation. That's a very unpopular view, but the way I look at it is like consider agents. The definition of an agent is that someone who is an AI application that can plan and make its own decisions. I consider that if you're providing an analogy to following a workflow, I'd say that's more akin to stand-up comedy. You're getting
Okay.
up there and actually improv. You're getting up there and thinking about what might work and having a bit of a sketch show. In litigation is more akin to an opera or a play where you've got a screenwriter, a playwright who writes the script, you've got a director who aligns each of the various different actors, and you've got the actors who have some limited set of agency to in the expression of how they would say their otherwise scripted lines. And I'd say that when you're looking at litigation, it's far more analogous to the play than it is to improv because you need to be able to understand exactly what happens and why it happened.
Yeah.
So I would say agents in litigation, to be honest, are very scary for me.
Yeah.
We use tried and tested predicted workflows with in calling elements of AI from time to time. I would never call it an agent.
Yeah. Do you find that your clients will have access to both a generic Gen AI and a specialist AI like Cicero?
Absolutely. I would not, under any circumstances, say don't buy your co-pilots, don't buy your ChatGPT equivalent. Everyone needs some sort of assistant in their library. We don't even offer that in Cicero. We offer a specialist AI that is designed to work very much on very specific workflows inside litigation. We do not position that this is an alternative to a general productivity tool that you'd use to write emails or spell check your briefs.
I'm not sure if this is a question that's better done in more detail after this session, Joe, but can you provide a chronology for a barrister from his brief in a personal injury claim?
Absolutely.
Ah,
Chronology is
okay.
the second use case that we produce. In Cicero, we've got three core use cases: investigations of matters of fact, building out chronologies, either exhaustive chronologies, which capture every single dated row, which, to be completely honest, are a little bit exhausting these days, or we've got a focused chronology that can be explicitly tied to certain issues of interest that can either be added manually or inferred from the list of issues that Cicero's automatically detected from the pleadings.
Okay. I've got a question here that tees you up nicely to talk about Cicero. AI is prone to hallucination. How does Cicero minimize or eliminate such errors in their products when using AI?
Really good question. So everything is based off the corpus that you upload. No access to the internet, no raw retrieval, no raw generation capability whatsoever. We've built a very sophisticated advanced RAG framework. Retrieval augmented generation is what RAG stands for, and it means that it's grounding its answer inside your documents. Now, inside any tool that uses LLMs, there's a risk
Mhm.
of hallucinated content. what we position here is we've built this to be quality controlled with a human in the loop so that a qualified reviewer of those documents is ultimately going to be the last line of defense. We never position that AI is good enough to say you don't need to read your underlying documents.
Okay.
What we would position to say is we will tell you which documents to read first and which ones have a very high chance of being heuristically relevant to your particular document set that you should read first.
Okay.
And it's your reading that will inform your judgment before, especially before you provide any substantive advice to a client.
Okay. This next question goes to something we were discussing a little bit earlier. What lessons from early adopters could help firms avoid costly mistakes when implementing legal AI?
I am. This is something that's going to ruffle a few feathers. I would avoid whole of firm implementations at this point. Start off with taking a narrow but concentrated focus on a small subset of a well understood and high value use case, and build that out to the nth degree. I'd say that the whole of firm adoptions run the risk of people who don't want to use these tools having a license and potentially taking resources away from those who would be otherwise strong adopters. Build out that series of use cases initially with that small champion group, and then scale it from there once it's proven to have value inside your firm.
Yeah, that does go against the grain, I would say. And Joe, how much upskilling is required for lawyers to be able to use AI properly, particularly senior lawyers who are bad at prompting AI?
So this is again where I'm probably against the grain. We of course have built our tool out to be able to be prompted and to be able to be used by people who are curious and interested in how this technology can advance their use cases. That having been said, we are absolutely committed to bringing along everyone on the journey who doesn't like prompting and doesn't want to prompt. I believe that there's an onus upon vendors to cater for those lawyers and not have to reinvent their understanding of how their profession works in order to take advantage of these tools. So option one, by all means, please get and understand how these tools can be used. Option two is wait for the right tool to come to you because it's coming. We're building it. Others are working in the same direction, and please don't feel if you use these tools and feel silly for having made a mistake, then it's not your fault. It's the accessibility of the platform that is also partly to blame for it.
Yeah. We've had some pretty fantastic questions there, and I just have two more of my own
Of
for you.
course.
First of all, reflecting on everything that you and I have discussed in the last 45 minutes, what words of wisdom do you have for litigators as we head into 2026 when it comes to rolling with the punches, given how much litigation is being reshaped by these new technologies?
I want to answer this with a bit of lived experience where I've seen this work really well. I had a barrister give me a call on a Friday afternoon at 4 p.m. He was dealing with a matter that had an element of insolvency to it, and he'd just been given 20,000 documents that had been dumped on him 2 weeks before the hearing date. Now, if he were to get an adjournment, it would not have been in his client's interest. There's a potential while trading while insolvent. So what he did was said, Joe, I've got these documents. We've got a team of 4 in the firm that we're working with. What can you do with us? Because there's way more documents than we have hours left to be able to read this stuff. So we loaded the documents into Cicero. It took 3 hours to process, and they spent the entire weekend querying it, approaching it from different angles. And they found 17 very good reasons not to put their client on the stand as they had intended to do. They also uncovered one particularly uncomfortable line of questioning for their opponent's lead witness, who happened to be up first. And so they proceeded with the trial. They pressed on that particular button and left it open for the next day, and then they immediately settled. And in the words of the barrister, it was a multi-million-dollar difference. So I've seen this accomplished, and that to me was a real eye-opening moment because we'd built this initially to reduce how much time and effort it would have taken to do certain tasks. We had no idea, or we didn't suspect that it would have this level of impact in helping litigators achieve a better outcome for their clients. And I think that's where this is going. It's making justice more equitable.
No, that's really cool. And just finally, Joe, for those who want to learn more about Cicero and Automatize's offerings more broadly, how can they get in touch? How can they learn more?
Yes, cicero.com.ai.
Okay.
And we'd love to hear from you if anything we've said today resonates.
Joseph Raymond.
Thank you so much. Cheers.
And thank you to Cicero by Automatize for its support of Lawyers Weekly. Thank you to the viewer for tuning in. We hope you enjoyed this session. We'll see you again next time.